Be seated.
Next case is Phantom of Brevard versus Brevard County.
Before we start, Mr. Knox, it occurred to me that I ought to make a couple of disclosures, primarily directed to you. You know that my brother represents a lot of these fireworks people, right? I assume that you. Okay. And I noticed in a footnote in Mr. Schumann's brief that Thunderbolt had been a party below, but they're no longer a party. Is that right? I recognize that name. I believe that's Kevin Marsh's company, and I'm sure that's was my brother's client, if not still. And I have met Mr. Marsh. You know, I can't remember the last time I saw him, but I have met him at a social function or two at my brother's house. So I make that disclosure to you all. You know what the reason that I'm making that disclosure. And I don't know anything about this particular issue. I don't believe that I've ever talked about, my brother and I don't talk about legal issues or cases. So, and there is also a possibility that when Rick was in my firm, that he had Thunderbolt at that time, but I really don't remember that. So, okay? Thank you, gentlemen.
All right, you can begin when you're ready.
May it please the court, my name is Mark Schumann, and I represent the plaintiff appellant here, Phantom of Brevard, Incorporated. This suit seeks to challenge the constitutionality of an ordinance, actually two ordinances, which for ease of reference we'll refer to as the ordinance, enacted by the county commissioners of Brevard, seeking to regulate in several material respects the sale and use of fireworks. It is the position of the appellant that the sale and use of fireworks throughout the state of Florida is an area of law that has been preempted by the Florida legislature. And as a consequence of that, this particular ordinance is encroaching upon an area which the state has reserved to itself, and therefore is violative of Article 8, Section 1.g of the Florida Constitution, and is therefore unconstitutional.
Do you contend that that's an express preemption?
We would suggest, Your Honor, that it is both express and implied. I wrestled with that term and concluded at some point during the time I was writing the brief that the utilization by the legislature in the very, very first section of the statute, and that's section 7091.001, that this chapter shall be applied uniformly throughout the state, expresses the intention of the legislature to preempt the field. We would also suggest to the court...
Why didn't they just do it then and say that no county or local government can get into this area like it was done in the lottery or the manufactured home installers?
I understand, Your Honor. I can't explain that. But our argument, of course, also is that even if the legislature failed to be so express, that the legislative history of the current statutory scheme, together with the subsequent history of efforts by the legislature to address amendments to the fireworks statute, clearly reflect the legislature's understanding that they are, in fact, preempting the field. Further, Your Honor, I would respectfully direct the court's attention to this very, very significant fact. In this statutory scheme, Chapter 791, there are 12 sections. In 3 of those sections, boards of county commissioners and other local governmental authorities are specifically given authority to act. And the area in which they are given authority to act is extremely limited and is defined in section 791.02. In that section, the legislature specifically said in the essentially first sentence that the Board of County Commissioners shall have power to adopt reasonable rules and regulations for the granting of permits for supervised public display of fireworks by fair associations, by amusement parks, and other organizations or groups of individuals when such public display is to take place outside of any municipality. In this case, the legislature then serving that the municipal authority has the authority to issue such permits if the display is taking place inside the municipality. Similarly, the county commissioner is referred to and further empowered in section 012 of chapter 791, where the legislature specifically stated that any state, county, or municipal law, rule, or ordinance may provide for more stringent regulations for the outdoor display of fireworks, but in no event may any such law be less stringent than NFPA 1123. And in this particular section, the legislature said the code for fireworks display, and by that I infer the legislature to mean that adopted by any county commission, shall not govern the display of any fireworks on private residential property and shall not govern the display of those items included under 791.014, which defines certain types of fireworks. Only in one other section, Your Honors, and that is in section 3 of this chapter, is a county commission empowered to act, and that is given authority in section 3 to require any organization conducting a public display of fireworks to require the exhibitor to post a bond. It is the appellant's position, Your Honor, that based on the rule of interpretation, statutory interpretation, of expression of one alternative is the equivalent of the exclusion of another. The fact that the legislature specifically empowered county commissioners and local governments to act in 3 of the given sections of the statute specifically reflects the legislature's intent that such county commissioners and local governments would have no authority to act under any other sections of the relevant statute. Your Honor, specifically, the phrase...
Can you tell me just tell me the gist of what the ordinance does that the statute does not do?
The ordinance, Your Honor, attempts to impose upon retail purchasers of fireworks and retail sellers of fireworks certain obligations for the obtaining of permits, for the proving by these individuals who seek to purchase and or sell fireworks their status as an exempt category under the statute, and also attempts...
It's like the bird exemption.
The bird exemption, and most critically, Your Honor, there's an exemption that's mentioned under 791.04, which talks about ceremonial use or in sporting events, where the statute specifically says that nothing in this statute shall prevent the use of fireworks for signal or ceremonial purposes in athletics or sports events. And that raises an interesting issue, Your Honor, because in its brief, the appellee suggests, does more than suggest, states on several occasions that the county has done no more but accept the definitions as were set forth by the legislature in the statute. And that is just not so. because in the second leg of the ordinance, which was enacted in April of this year, and which, by the way, may be found in the appendix at Exhibit 7, the county ordinance attempts to define the word ceremonial. That is an action that they certainly are not authorized by this statute to do, and certainly would be contrary to the directive contained in the very first sentence of the statute, that this statute shall be enforced uniformly throughout the state. Nothing would prevent, strike that, if this county is allowed to define ceremonial, nothing prevents any other county from defining ceremonial in any way that it sees fit, or using any dictionary that it might find appropriate. Your Honor, we respectfully submit that such actions were specifically forbidden by the legislature when it had utilized the phrase, as inartful as it is, that this chapter shall be applied uniformly throughout the state.
Let me ask you about the bird exemption, because that seems, from reading that second DCA opinion, that seems to be what's perceived by some, maybe the county, as a gaping hole in the statute that allows the sale of fireworks. The legislature has prohibited the sale of fireworks, but created an exemption for people who are chasing birds in an agricultural setting. Is that
That's correct.
And as I understand it, what happens is the retail purchaser goes in to buy fireworks and signs some certification that, you know, they're using it to chase birds in an agricultural setting. Is that right?
That's my understanding, Your Honor.
Now, the county is trying to kind of plug that loophole and put the onus on the fireworks seller to verify that that's factual. Is that what they're doing?
My understanding is that the ordinance is attempting to put the fireworks seller in the shoes of a law enforcement officer, which we would respectfully submit as an inappropriate delegation of law enforcement.
Does the county have the authority to enforce Chapter 791 by directive from the legislature?
It absolutely does, but it must comply with the legislative mandate set forth in the statute. Specifically, my memory is, Your Honor, that the statute says that with reference to obtaining the right to purchase fireworks for the chasing away of birds, that's something that's going to be conducted through the Department of Agriculture. And I believe that's specifically referenced in the statute. I believe
the county doesn't have the enforcement authority over the bird exemption. Is that what you're saying?
It has enforcement authority, but it doesn't have the authority to propose and promulgate additional regulations. That was specifically delegated to the Department of Agriculture pursuant to Section 7 of the statute.
I remember reading that. But under the penumbra of its enforcement authority, cannot the county enact an ordinance that makes enforcement easier?
It might, Your Honor, were it not for the fact that in this case and with this statute, in light of the clear language of the statute in Section 1, the legislative history of the statute, as well as the subsequent legislative history, which we discussed at length in our briefs, it was the specific intent of the legislature that local authorities were to have no power and no authority to enact any additional legislation. That was the sum and substance of all the votes that were taken before both the Senate and the House in 1987. That was the substance of all the discussions that went on before the committees, where people were suggesting that, well, we know that perhaps some folks want to have more stringent regulations.
But Mr. Shubin, under Chapter 791, people are not supposed to be able to buy fireworks using the agricultural exemption if, in fact, they're not going to use them for that purpose. If their subjective intent is to take them and shoot them off in their backyard, right? I mean, they're not supposed to be able to invoke that exemption, right?
Your Honor, the only comment I can make in response is that Section 07 of Chapter 791 specifically says, and such use referring to frightening birds from agricultural works and fish hatcheries shall be governed entirely by the rules prescribed by the Department of Agriculture and Consumer Services. There's a specific designation of authority in the Department of Agriculture to promulgate rules, and those are the rules and only those rules that apply to that specific
Well, all
use.
right, let's say hypothetically that I walked into a fireworks store on July 3rd, and I signed one of those sheets and said that I was going to use it to chase birds off an agricultural property. And I had really no subjective intent to do that, and the county followed me, and they followed me out to my home in Sundry and watched me set them off in my driveway. Now, are you saying that the county doesn't have any authority to take some sort of enforcement action there under the statute?
I would respectfully submit, Your Honor, that the only enforcement action they could take is perhaps to suggest that that particular individual was in violation of the rules promulgated by the Department of Agriculture, because those are the only rules that somebody using or ostensibly using fireworks for the purpose of scaring away fish is subject to.
So the enforcement, so it's a statute that really has no teeth in it.
Your Honor, that's probably the sum of this entire thing. It's a very inartfully drawn statute. But that, with respect, Your Honor, doesn't justify each of the counties jumping in and attempting to fashion their own statute. The proper course here is for the Association of Counties to lobby the legislature to enact a more broad-based statute, and that's exactly what happened apparently in 2004. That particular bill that was put before the legislature is part of our brief and discussed in our brief, and is also part of the exhibit appendix. It's found at Exhibits 4 and 5, where the legislature was enacting a new amendment to the fireworks statute, Chapter 791, which specifically said that it was going to be permissible for local governments to enact more stringent regulations. Two comments on that. First of all, that particular enactment in its entirety died. So that didn't become law. But if the legislature itself believed that counties already had authority to enact such legislation, then it wouldn't have been necessary for the legislature to propose this legislation in 2004, seeking to give the county and municipal authorities that specific authority. The legislature's inclusion of that specific provision in the proposed 2004 bill, which is found in Exhibit 4 specifically in the appendix, clearly shows that it was the legislature's understanding that, based on its own legislative history, that no municipal authority, no county commission was to have any rule drafting authority regarding the sale and use of fireworks, and that was exclusively reserved to the legislature.
You're asking us to declare conflict with fandom versus Pinellas.
Absolutely, Your Honor. And
You're taking it head on. There's no way to distinguish it, right?
Your Honor, we're absolutely submitting that for the very, very simple basis that in Phantom of Clearwater, the court ignored the legislative history of this statute, didn't examine it on its own, even though it was empowered to do so, didn't ask counsel to address the issue, and it's astonishing, and it can be seen.
We ignore that legislative history all the time, Mr. Schuman. When the statute is clear, that's the first place we look. And we say, okay, the statute's clear, we understand what it says, we don't need to go to legislative history, right?
If a statute is clear, then the Supreme Court of Florida has stated that a court may not use legislative history to alter that clear legislation. But where the legislation is either ambiguous or the court wants to confirm its own understanding and interpretation of that legislation, looking at legislative history is appropriate, and that issue is addressed in our...
Is this a patent ambiguity? I'm sorry, I'll yield to Judge
Oh, I'm
Griffin.
sorry, Your Honor. Thank you very much.
Is this a patent ambiguity or a latent ambiguity?
Well, Your Honor, I don't know if it makes a difference. For the simple reason, and I'd like to address, if I may, Your Honor, the question you posed previously, and that is taking the Clearwater case head on. Because the court ducked the issue, and they really did duck the issue. They said it's surplusage. This language in the statute that this will be enforced uniformly throughout the state is surplusage, which has specifically been, that type of approach has specifically been decried by the Supreme Court of Florida, which has repeatedly said that no language in the statute should be viewed as being a surplus and unnecessary, that every sentence and every word must be given its fair and accurate meaning. I would like to, in the last moment that I have available, Your Honor, to make this comment. In their effort to deflect the court's attention from the words of this statute and the legislative history of this statute, the appellee spends a great deal of time discussing the Section 1123 of the National Fire Prevention Association regulations, which specifically are referred to in the statute as being the guideline to be followed for the public display of fireworks. Nowhere in the NFPA 1123 is there any discussion of its application to private consumers purchasing fireworks. And specifically, Your Honor, in the statute, in NFPA itself, at Article 1.1.3, it says specifically this statute is not to be construed, to be used, to apply to the use of fireworks by the general public. But what the appellee does is, because the NFPA statute says that the NFPA can regulate public displays of fireworks if they include consumer fireworks, the appellee attempts to make the leap that therefore, because the NFPA rule regulates consumer fireworks when used in a public display, that it therefore rules and controls the use and sale of consumer fireworks in private sale. We respectfully request the court to not be misdirected by these arguments by the county. We respectfully ask the court to review the legislative history underlying Chapter 791 and to reverse the circuit court, which was compelled by the holding in the Clearwater case, and find that the ordinance enacted by the county of BREVARD is unconstitutional in that it encroaches upon an area preempted by the state. Thank you very much.
Thank you, Counsel.
Police Court, I'm Scott Knox, County Attorney representing BREVARD County. Of course, Your Honors, we would commend you for reading the Phantom Clearwater case as support for our proposition that this ordinance is not preempted by state law.
What about Mr. Schuman's last point? I mean, Judge Altenburn says, well, when they say shall be applied uniformly throughout the state, that's surplusage because all general laws are applied uniformly throughout the state. And I'm sure Mr. Schuman correctly cites our Supreme Court for the proposition that we should give meaning and intent to every word and phrase in a statute, and we should never assume that our legislature would succumb to the use of surplusage in the statute.
I would, let's assume for the sake of argument that Mr. Schuman's correct about that, just for a second. The problem Mr. Schuman has is he doesn't read the whole statute. All he does is read the part about the uniformity of application. He doesn't read the second sentence of that same statute, which says that the county and local law enforcement is entitled to enforce the statute. And that's the flaw in Phantom's argument in this case. Because what the uniformity requirement applies to is the standards and the exemptions and the prohibitions in the statute. The statute says it's unlawful for any person, firm, corporation, partnership to offer for sale, expose for sale, sell at retail, which is really what the big problem is in most counties, or to use or explode any fireworks. So you can't sell it at retail, you can't use it, you can't explode it anywhere. That's what the statute says. The counties are entitled to enforce that. They're authorized to enforce that statute. So if you go down to the exemption provision, it says there's several exemptions, one of which is you can sell at wholesale. So how do you determine whether you're selling at wholesale or you're selling at retail? The county, who's charged with enforcing this particular statute, has the implicit authority under home rule authority to set out rules to determine when you qualify for that exemption and when you don't.
How about
Because
the ag exemption?
Pardon me?
How about the bird exemption?
The bird exemption doesn't.
That's the big rub, isn't it? The bird exemption. I mean,
It's not wholesale. It's the big rub. But
wholesale.
the bird is also a problem.
Yeah.
But the reason Mr. Phantom's wrong about that argument is because the statute that he refers to, that gives the authority to the Department of Agriculture and Consumer Services, does not apply to how you determine whether you sell at wholesale, whether you're selling for birds, whether you're selling for anything. It says specifically that their authority is limited to how those products are used, not how you determine whether they're qualified under that section. So
What is an acceptable agricultural use? Is that what you're talking about? In other words,
yeah,
how agricultural use is defined is
when, where, and how you can use fireworks to frighten off birds. Whether or not you're qualified to do that as a bona fide agricultural use, they don't talk about it in the statute at all. And then they don't authorize the Department of Agriculture to determine what that is or when that occurs. Just as you can determine when you can how you can use that, how you can use your explosives, how you can use your fireworks.
What are the penalties for violating the ordinance?
The penalties are treated as a county ordinance violation in our ordinance.
Second-degree misdemeanor?
It's up to a $500 fine, and it's the equivalent of a second-degree misdemeanor. Although it's up to
Is that consonant with the penalties for violating the statute?
That's not that. I think the statute is a little stricter than that. I think the statute's a first-degree misdemeanor. If I recall.
Does the county have authority to promulgate different penalties than the legislature under the guise of enforcement of the statute?
Yes, we do, Your Honor, if it's a less stringent penalty. Which is
If
what
they're less stringent.
Less stringent. Yeah, we did not do what the Pinellas County did. We didn't incorporate both the statutory penalty and the ordinance penalty. We eliminated the statutory penalty. So we only have the less stringent penalty, which is $500 fine or the equivalent of second-degree misdemeanor as opposed to first-degree misdemeanor. So I think the problem here is that Phantom's missing the fact that the county has the enforcement authority. And consequently, legislative history doesn't really come into play because legislative history that he's talking about only says that they rejected arguments that the county should have the authority to impose more stringent regulations. That's not what the county has done in this case. What the county has done is implement its enforcement authority by saying, we want to know whether you're selling at retail or whether you're selling at wholesale. We want to know if you qualify for the pouring and blasting exemption.
So you're saying it really makes no difference whether there was a general manifestation of an intent to preempt because you're acting under one of the particular subsections where the legislature expressly gave the county authority to act.
That's correct, Your Honor. And we're completely consistent with what the statute says in terms of prohibitions, exemptions, and everything else. The thing that the legislature does not address is how do you prove that you qualify for these exemptions. There's not a word in the statute about that procedure or those rules. And that's what the county is required to enforce, whether you are exempt or whether you're not exempt. So we've got to set up rules to determine if you are or if you're not. And that's what we've done with this ordinance. That's all we've done with this ordinance. We've adopted everything else that's in the statute in terms of the prohibitions and the exemptions.
How's it working for you so far?
Well, it hasn't worked at all.
Judging by my neighborhood on July 4th, still a lot of fireworks.
I think there's been a lax enforcement pending this decision, whatever it may be. I think that's pretty much where we are. In addition, Your Honor, I don't think there's any issue about this being expressly preempted. I think clearly the statute grants the county's authorities in different areas, and whether it goes to the extent that the county thinks it does or whether it doesn't really make any difference in this case because the ordinance that we're dealing with doesn't really address the types of prohibitions that Mr. Schuman was raising with you. You only deal with the simple outdoor display in a public audience type of environment. They don't deal with individual outdoor displays on private property or anything like that. The ordinance is strictly limited to what it does in that regard. However, that's not the preemption. Clearly, the county has the authority to do those kinds of things. And we also have the authority to regulate, supervise public displays. So there's no express preemption. And I think the big problem in this case is that Phantom has just missed, as they went through and listed all the things that the county can do under the statute, they ignored 791.001, which says that the county has the ability to enforce it as well. That's what they've missed here. And because we have tried to implement our enforcement authority by adopting rules to determine when you're exempt and when you're not exempt and when you qualify for being able to sell and when you don't, which is what we're required to do, I think that's where the argument on the other side has fallen down, because they haven't acknowledged that at all in any way. So I don't think the county's preempted. I think the ordinance is entirely consistent with what the law says, primarily because the law is silent on the issue of how you determine whether somebody's exempt or not. And I think that's all I have to say. Thank you.
Thank you, counsel.